Hi, Paul. Thank you for coming onto my channel. Do you want to just tell my viewers who you are, what you do, and what your firm does?
My name's Paul Dounis. I'm a restructuring partner at the firm RSM. I'll speak about RSM in a moment. But personally, I've been restructuring, talking to and advising managers, mainly distressed businesses, at various forms of distress, whether that be turnaround, restructuring, or I'm also a licensed insolvency practitioner. So I will take formal appointments as an administrator or a liquidator, depending on obviously the state of that particular business. I've operated in Sydney. I also have operated some time in London, and now in Scotland, I head up the recovery team here in Edinburgh. The firm RSM is a global firm of accountants. We turn over roughly £4.5 billion globally. In the UK, we turn over around 350 million. We have around 3,000 staff, 35 offices across the UK. In Scotland, we have 5 offices in Scotland. With about 200 staff overall. Yeah, that's the size of the business.
I actually wanted to talk about property, but I'm going to open it up a bit, and I'm just going to talk about businesses in general that go into a process and property companies in general that go into a process.
Yeah, absolutely.
What do you think is going to happen in terms of insolvencies and administration over the next couple of years?
That's a very good question, and probably a loaded one as well, but that's fine. Interestingly, obviously with COVID-19 at the moment, what we're seeing is a lot of businesses have been impacted by the ability to generate income. So they can't generate income. Yes, they can furlough staff, they can mothball sites, but at the moment it's okay. They could probably struggle along for a little while. And at the same time, mainly the courts are closed. So we're not seeing much in the way of creditor-led insolvency work. Yes, certain directors are taking the view that they can no longer continue, so they will put their company into administration. But that process has been slow. What I expect will happen is once we come out of lockdown and we start to see the courts reopen, I think what we're going to have is we're going to have landlords saying to their tenant, COVID-19 no longer applies, you need to bring your arrears up to date. You're going to have the banks asking all the borrowers that they've lent money to, whether it be a business interruption loan or a bounce back loan, saying, well, now you have to repay that money. And I think from that, we're going to probably see a significant increase in businesses, unfortunately, going into administration. So I think the next 12 to 18 months is going to be a busy time for the restructuring sector.
So a few of my viewers have made requests saying, Shaf, how do you source bankrupt property? And I want to bring it out bigger than that. What I want to do is I want to talk about basically businesses that go into insolvency, the processes you use to try and save them. If you do have to put them through a process, how can my viewers essentially get to the front of the queue to have a look at the business and what some of the pitfalls are?
Well, I guess if you're looking at the acquisition element, I mean, typically we try and get involved with a business as soon as they start to see signs of distress. And part of the solution might be actually, it just needs a bit of hand-holding management, a bit of working capital management, introducing some additional maybe management skills, so we can help turn that business around. If it goes beyond that, we can look at certain things like you might have seen, the CVAs have been have been seen in the public quite a lot. You talk about the big retail businesses who have done CVA arrangements, mainly to try and reduce the amount of stores they might hold or re-gear their leases with their various landlords. Beyond that, you're probably looking at a sale of the business. And I think that's where your consumers are most likely to look at. Typically, these days, there are 2 elements of when you're trying to sell a business. Now, we might start the process prior to an insolvency. So what we're calling usually an accelerated marketing campaign with a view to trying to find a buyer for the business as a going concern. So we will start that marketing process at least a few weeks before an insolvency is even put into place. And typically that's usually ends up being what we call a pre-pack. So you might have seen that in the press, pre-pack arrangements. So effectively what happens is the business is marketed, a buyer is found, a deal is agreed and negotiated. Then once the agreement is ready to be signed, the company enters into administration or insolvency. The deal is effected on the same day, and that allows the business to continue going forward with limited disruption to the customers and suppliers. So that's
what you might see, the other area where you would potentially see a sale of distressed assets is actually the administrator gets appointed, or I get appointed as trustee if it's a personal case, or as you say, administrator or liquidator if it's a corporate case. We could then look to sell the business thereafter. So we might start the marketing process at the time we're appointed. That is, typically they are quite limited in time, because actually what you don't necessarily want to be doing as an administrator is to trade a business for a long period of time after it's already in administration. It can be quite costly. You might have limited access to funding. You want to try and find a sale or a buyer as quickly as possible before the business runs out of cash. And any value enhancement from selling as a going concern is eradicated.
So what is the process of marketing a business when it's up for sale? How does that work?
Firstly, what we do, we as you say, we're a national firm, so we have a national, we have a website of contacts that anything that comes to market, we sort of break them down into the various sectors. So depending on where the business sits, in the sector it sits, we will send a note out. Usually it's in the form of a sort of teaser document, so it gives you a description of the business. That goes out. We ask for any expressions of interest, in return for which we'd ask for buyers to sign up to a non-disclosure agreement or a confidentiality agreement before we release further information. We don't generally, there used to be a case where you would advertise businesses in the press. That doesn't necessarily happen as much these days, typically because you need to be careful, particularly if the business is still trading, that you don't want to put off customers who become aware that the company that they're dealing with is potentially going bust. So that could start the business to unwind before you actually find a buyer, and then you lose your value. So typically it'll be through agents, it'll be through the sector contacts we have, and also we'll talk to management and ask them, who are the main competitors in their market. And we will target them, as well as the private equity houses, because they will always be interested in some sort of deal if the business has some underlying viability.
So how do one of my viewers essentially get onto a list so they are informed about any businesses that are going into administration?
Approach the IPs directly, approach the firms directly and say, listen, this is the sort of buyer I am, this is the sort of asset that I'm interested in, and get them to add you to their database. That's probably the best way of doing it.
So essentially what you're saying is my viewers should contact insolvency practitioners and say, excuse me, my name's John Smith. I am interested in property businesses. If you have any property businesses, please contact me. It's as easy as that.
It's as easy as that. I mean, to be fair, we would vet you. We'd need to vet, obviously, who the buyers are, because in circumstances where you're trying to sell a business quite quickly with limited time and limited cash, you don't want, I guess, for want of a better word, time wasters. So you want to know that they are people who have the available resources and can move quickly to actually get a deal done.
That's brilliant. Now, all businesses have to be advertised in the Gazette. Now, let me tell you how I basically look for distressed businesses. I just go on the Gazette and I look at where an administrator has been appointed. Is there a more efficient way of doing this rather than just looking at the Gazette?
Well, unfortunately, the issue with the Gazette is, particularly on administrations, as you said there, Shaf, they only get advertised once the administrator's already been appointed. Okay. So in that case, it may well be too late, because, as I said, you might have started the process and actually done the deal on administration. So you'll have missed out because the business will already have been sold. With liquidations, actually, the requirement is to advertise once a petition is served. So you might get prior notice because the company has not yet entered into liquidation, so it might still be available. But to be fair, looking at the Gazette, as I said, will give you an idea of what businesses have gone into a process, but not necessarily what might be actually on the market at that time.
The other thing I do is I have a Google alert, for going into administration and going into liquidation. But again, that's after the process has started.
Yes.
Yeah. So that there isn't a more efficient way of doing it, apart from A, go on the Gazette, B, set up a Google alert, and C, contact insolvency practitioners. That's the three ways of doing it.
I mean, there are other software available out there. For example, we as a firm have a program called Tracker. What we do is we monitor businesses and their health across the UK. Now you can sign up to that product. What that then does, it gives you alerts. But again, most of these alerts are usually sprung from either a Gazette advertisement or it might be a CCJ. So, for example, if a creditor's tried to issue a judgment, accounting court judgment against the company, it gives you an idea that the company is struggling. Doesn't necessarily, however, translate that business is necessarily going into a process or is being advertised for sale.
Okay, perfect. Now, the vetting process that you go through, Paul, what do you look at? So you talked about a vetting process. If somebody contacts your firm, what do you look at?
Well, we'll look at their accounts, what they filed at Companies House. We'll ask them for any updated management accounts. We'll seek to understand what free cash they've got, what access to facilities they've got, what their lending criteria or investment criteria might look like. For example, if I'm going to buy a property that's £1 million, will I be buying that in cash? So do I have the cash reserves to make that acquisition, or will I be doing it in some form of debt? And then, so that element, you'd see at what security is available within that particular business or particular entrepreneur to put up a security to secure enough cash to do a deal.
Okay, so essentially you're looking at people who have the ability to move fast.
Correct.
Yeah.
That's exactly what we need in any insolvency sale.
What are some of the pitfalls when it comes to an insolvency sale? From a purchaser's point of view, time isn't going to be on your side. Do you want to just talk me through that, how fast the process works, etc.?
Yeah, I mean, to be fair, the process is usually, the timing available for a process is usually dictated by actually the company's available cash reserves, because once you run out of cash, you can no longer continue. So in that case, we've run processes where we've done a deal within 2 to 3 weeks. In other circumstances, I've actually done one over 7 days, including weekends, of course. Up to 6, maybe 8 weeks if you've got a bit of time to actually get the deal done. But in terms of pitfalls, yes, timing obviously is a key one. The other one, because of the timing aspect, you get limited amount of time to actually do your diligence. So if you want to look underneath this business to see exactly what it's involved, what it is you're actually buying. And that period of time is limited, in particular when you note that when an administrator sells a business, he will not give you any warranties in relation to that business. So you'll need to be certain. Effectively, you're buying as you see it. So if there are issues with it and you haven't already found out what they are, then what you do is you price risk it. So if there is a risk to buying these businesses, but that should be reflected in the price you offer.
Okay, and it's the same in terms of property,
absolutely.
Whether it's a property business or whether it's a trading business, there is no warranties, there's no indemnities, there's no warranties, there's nothing. You're just buying it sold to see.
You're buying sold to scene, exactly right. I mean, sometimes with property, you might just get something about title, i.e. the administrator has the ability to sell the asset. Other than that, you're not getting much. So you need to get your agents, your lawyers engaged to go out and review valuations, make sure that legal documents are okay. Other areas with not property business as such, but trading businesses is stock. Because obviously you might be buying stock, but you need to be certain whether there's a reservation of title over that stock. Because if creditor comes along and says, actually, that stock that you thought you bought is mine, then you'll have to return that stock.
Okay. Now, let's talk about staff. Some businesses you're selling might have staff. Be you paid over or not?
Yes, staff, typically it's a UK issue. I mean, to be fair, we probably have a whole session on just staffing issues. But yes, in the UK, if you sell a business, then the staff will transfer over to the new co or the new buyer. Now that effectively means that their employee entitlements will continue to accrue. So you're effectively picking up those employee entitlements. What we recommend to anyone looking at businesses is get proper legal advice in place, because what you want to ensure that a proper consultation process is run with those staff. That prevents any claims subsequently falling on you as the buyer that you didn't run a proper process. Because if you choose to, for example, reconfigure the employees, you need to potentially make some staff redundant. You need to ensure that you run a proper process so that there's no claims for unfair dismissal or protective awards which can be made against the buyer post the acquisition. Now,
we're going to disregard property businesses here, but some businesses will have leases. So let's create a company name, Widget Limited, rents a building in Edinburgh. Okay. If you buy that business, do you have to take on that lease?
No, you do not, is the short answer. I mean, I guess the beauty of a sale out of an insolvency process is, as a buyer, you can other than employees, of course, you can effectively cherry pick what assets you want to buy, what contracts you want to continue with, and you can leave the other ones behind. And obviously, you're buying the assets debt free. So no, you do not have to take on that lease. What that does do, of course, is gives you an opportunity to try and negotiate either a new lease or re-gear that existing lease. So there's a limited opportunity for you to do that. Typically what we do as administrators is we will offer, if you want to stay on that site for at least a short period of time while you explore your options, we'll tend to offer what's called a license to occupy. So that's a short-term license to allow you to continue in that premises, but under the same terms as the existing company, until you have an opportunity to re-gear or move out or whatever other options you want to explore.
Now, in terms of legal advice, you know the lawyers I would use for this, but in terms of legal advice, can you give my viewers some advice onto the specialisms of the lawyer they should use to do the documentation, etc., for a deal?
Yeah, absolutely. To be fair, this is a very valid point you make, Shaf, because actually, not a lot of times we see buyers engage lawyers who don't know much about insolvency and insolvency sales. Now that can take up a huge amount of time, waste a lot of time, because you need to engage somebody that has some experience of buying assets out of an insolvency process, because they will understand the types of clauses that administrator will accept and those he won't accept. So that's one element. The other element is, particularly for if you're buying property and that's part of the sale, obviously use a property lawyer. Employment lawyers are obviously very important here, particularly around the 2P issues. You need to engage someone who has good experience around employment law. And finally, anyone who deals with corporate lawyers who deal with diligence, the legal diligence on the assets you're looking to buy and the business you're looking to acquire.
So essentially, another tip we're giving the viewers is they are going to need a team of lawyers to be able to buy a decent business out of administration. This is not a job for John Smith's legal firm on the high street, two-man band or one-man band. This is a firm which has an insolvency lawyer, a property lawyer, an employment lawyer, yeah?
And a corporate lawyer, yep.
And a corporate lawyer.
Absolutely.
Is this something you would take into account? You've got 4 bids.
Yes.
Basically, the highest bid is from somebody who's clearly green around the ears. They don't have the correct representation. Is that something you would take into account?
Absolutely.
Absolutely.
We consider that on all fronts, who they're actually using as a lawyer, because it goes to the heart of credibility and ability to deliver. And this is what we focus on. We want to do a deal. We want to do it quickly. So we're looking at somebody who's got the right representation in order to be able to deliver that deal. And just to give you another example, Shaf, occasionally, if we're short of time, what we might be doing is running a few buyers at the same time. So effectively, it becomes almost like a contract race. So, the buyer who can do the deal in the time that's allotted to them the quickest. And obviously, if you've got the right representation, that's going to mean you get there quicker than your competitive buyer.
So just saying layman's terms, for my viewers, what you're saying here is you might offer to sell the assets to 5 different people or 4 different people or 3 different people, and whoever ties up the contract first is going to basically get that business or property.
Potentially, yes. Yeah, we've done that in the past. It doesn't happen as often these days, but that's a process that we've run just to make sure that we get that deal delivered. As
a landlord, I have come across the concept of landlord's hypothec quite often.
Okay,
yeah?
Yes.
And I have used it to my advantage when we are due huge sums of money.
Yes.
Could you break this down into very, very basic terms for my viewers? Because to a lot of them won't understand what that means. Can you just break down how a landlord can use it to his advantage?
The first thing to say about Hypothec is that that's purely a Scottish rule, or it's not actually a rule. I think it's a common law issue. So Hypothec only relates to property in Scotland. So in effect, if I am a landlord and I have a tenant who goes into insolvency, whether that be liquidation or administration, it means that if there are any arrears of rent, not service charge, not anything else, but arrears of rent, means that in respect of those arrears, I effectively am awarded a security over the assets held within that premises. So whether it be plant and equipment, whether it be stock, any physical assets on that site, those assets, once they're sold, need to go firstly towards paying my arrears as the landlord. So you can effectively, that's the legal position. I mean, I guess from a negotiating point, what that allows you to do is if you've got, let's say, for example, the administrator turns to you and says, I've sold the business, here's the new buyer, and you want to negotiate a new deal with that, a new lease with that tenant or the new buyer, then obviously what you might want to ensure is your arrears get paid up to date, because they will have effectively acquired the assets over which you hold security. So it gives you some leverage when you're negotiating that lease with the new tenant.
In terms of landlords Hypothec, there's been instances where we have had arrears, okay, and an administrator has been appointed, and we've contacted the administrator and says, look, here's our arrears, they're £18,000. The administrator rather will just turn around and say, do you know what, just keep the stock, the plant and the machinery.
Yeah, exactly. What the administrator will do, he'll make a commercial decision. So what he'll say is, using your example, you're owed £18,000 in arrears. The first thing the administrator will do is he'll get a valuation of that equipment. If that valuation comes in at 18 or less, he's more likely to say to you, you take the assets, you sell them. He might ask you, of course, to account to him. So he might say, so for example, if you're able to secure a sale of those assets at, say, 30K, don't know how you would do that, then potentially you might have to account to him for the surplus or the difference between the two figures. But in the main, I suspect, if the assets are only worth 10K, for example, the likelihood is there won't be any equity. So he'll allow you to deal with those assets and give you, because what you've got to remember, the Hypothec doesn't give you the power of sale, it only gives you security. But what the administrator could do is say, listen, I'm abandoning those assets, I'm allowing you to sell them.
So in Scotland, we have the position of landlords Hypothec. What is the situation in England?
Well, there is no Hypothec. There is no Hypothec in England. So simply put, they don't have that. They have no preferential treatment like you do in Scotland.
So I've bought a number of property assets and basically businesses from administrators over the years. And I want to talk you through my strategy, and I might as well find out from an expert if I should do anything to improve this. So my strategy is, last year, for example, from recollection, 5 townhouses for sale in Charlotte Square. Our strategy was, we went in, we provided proof of funds. I think the deal was about £6 million, but we went in with a reasonably lowball figure. Okay, we didn't get that deal. We didn't secure that deal. What do you think we did wrong there? Just we didn't offer enough?
Well, I suspect that's the short answer is probably yes. You probably didn't offer enough, because if you've come to me, I know you've got the access to the funding, so that's good, and you've obviously provided the proof of funding. So, as from an administration perspective, I know that you're a credible buyer and you've got the ability to do the deal and do it quickly. So that ticks that particular box. I guess the other box that an administrator needs to tick is to make sure that he's maximising the value or the return to the creditors. So he may well have received offers in excess of what you had offered and said, well, actually, that's a better deal. That will result in a better outcome. So his duty is to make sure that, creditors get as much of their money back as possible. So I suspect you just pitched it too low.
So, Paul, let's say I know of a business, okay, that is going to go into administration. The reason I know is that my tenant, and they haven't paid the rent for 6 months, the principal comes in and says, excuse me, Shaf, I'm going to go into administration. What's to stop me from just saying to him, look, I tell you what, I'll just buy your company? The
difficulty there is what happens when a director or a business owner is aware that the company is either insolvent or is facing insolvency. His duties as a director switch from that of the company to the creditors. I guess where I'm going with this is he needs to ensure that if he's selling assets or the business to you prior to an insolvency event, that he's actually achieving market value. And that could be quite difficult to justify if he hasn't, for example, actively marketed that business. So the risk for you as the buyer is that you buy it at a discounted price, or a heavily discounted price. The administrator gets appointed. He then looks at that transaction and says, actually, this is a gratuitous alienation. Now, for layman's terms, it's a transfer at undervalue. So I've transferred an asset to somebody at below its market value at a time when I know the business is insolvent. What can then happen is that administrator might approach you as the buyer and say, you've underpaid for this, you'll need to pay me. We either do one of two things, you pay me the excess, or two, we reverse that transaction. So that is the risk of trying to buy assets pre-insolvency at a discounted price.
So what would your advice be to viewers if they know of a business, using the example that I've got, just essentially just wait until the business goes into administration, have your due diligence done in advance and be the first person to buy it off the administrator?
Yeah, I mean, that's one way of doing it. And the other way of doing it is potentially suggesting to the director that he needs to put the business on the market and actually advertise it so that you are part of that process. Because as long as I said, the point is he needs to be able to justify to an administrator that he's sought the best price for that asset, rather than taking the only offer that he's had on, brought forward because he's struggling and he wants to get cash quickly.
Okay. Now, could you just run through, Paul? I don't want you to name any companies or any buildings, but just give 2 or 3 examples of property assets and property companies you've sold. What are the various things you've done? Just to give my viewers an answer, and then we'll just do a recap on how to get to the front, how to get in front of an administration and how to get to the front of the queue.
There was a deal we did probably about 2 or 3 years ago now. It was a student accommodation block. There were 2 banks involved. In fact, they'd lent quite a lot of money to this development. The company had to go into administration. It was well below water. So we were appointed administrators by the leading banker, the first ranking charge. Now, the site had just started operating. So we had some students in already. So what we did on that case, we appointed an agent to manage the income that was being generated. We got them to also advertise the fact that we were open for business. So that allowed us to maintain a rental income and an income whilst we sought to sell the actual building itself as a going concern. Now that took, that from start to finish, that took about 12 months. But the actual process for finding a buyer is we engaged a national agent in that case, a national agent with contacts in the sector who advertised, went out to approach other buyers in that particular market. We ran a process where we asked bidders to have a look at the site. We gave them a certain number of weeks to come up with an offer. Once we looked at the offers that had been submitted, we took 2 or 3 parties through to what we call preferred bidder status, and we allowed each of them to run their diligence process in order then to come up with a final offer. And once we got the best final offer that we had, we did that deal. In that case, we managed to get at least the first lender out in full, so they were repaid. So that's one type of deal. Another deal we've done more recently is, I'll run through a sort of pre-pack scenario. So a business that had a number of retail outlets, about 35 retail outlets. So the process with that was we were engaged quite early on in the process. So i.e. before the company went into administration. We looked at various ways of returning that business to profitability. Ultimately, when we did a breakdown of profitability by store, we worked out there were quite a few businesses or quite a few sites that were not actually generating a profit, were actually quite loss-making. So we thought, well, actually, the best thing to do is to put this business on the market, put that information out there, approach, again, trade buyers, PE houses, and this was all pre-insolvency. And obviously each of them wanted to look at how each site was generating, what income was being generated from each store. Now we had a range of buyers in that case. So certain buyers wanted certain sites, others wanted others. So we ended up doing 2 or 3 different deals to sell. And so we carved up that business. But what that allowed to do, because we mentioned the 2P issue and the employee issue, the thing is with employees, if you are at a particular site, let's say, for example, that site is closing, it's okay to make those staff redundant because that site is not being sold. But if it's being acquired, then it's legitimate for the new co to only acquire the staff connected to that particular store. So there was a bit of toing and froing over the head office staff and whether or not they would transfer and to whom they would transfer. But that allowed us to, it gave us enough time because we continued trading those businesses as well just before we sold them.
Now, final question. A number of my viewers, have a large residential property portfolio. They know nothing about commercial property, so they're watching my channel. One of the ways that I have done quite well over the years is buying property and businesses from administrators. I've done quite well buying property from administrators. What 5 pointers can you give my viewers so they can get to the front of the queue when it comes to buying property from administrators?
The first thing is, as I said, probably proof of funding. That is probably number 1. Number 2 is having the right representation team in place to allow you to do that deal quickly. I would suggest being flexible in your approach in terms of the sort of pricing that you want to offer. So for example, you might want to price an asset at a slightly below valuation, or you might want to offer at valuation. Now, as long as you can get in, as long as you price it high enough, it doesn't prevent you subsequently from what I call price chipping. But, provided you've got substantive reasons for reducing your price subsequently, that then at least it gives you, like, for example, in your case, you missed out because you priced it too low. So you weren't even involved in second stage. I think they're probably the three key things if you're buying property assets specifically, and obviously understanding whether it's freehold, whether it's leasehold, what is it you're actually buying, and finally making sure that you get diligence done as best as possible.
Okay, so that's an interesting point about the price chip one.
Yes.
So this isn't just done out of maliciousness. It may well be that a building is worth £1 million. Okay, when fully let, an investment, that particular building's worth £2 million. Vacant possession value is £1 million. So
Yes.
I'm the buyer, I offer £900,000. So essentially what we're saying here is I offer £900,000 for it. I then basically, through the diligence process, find that the building is riddled with asbestos and it's going to cost £200,000 to remove. And I go and ask for a £200,000 discount.
That's what we're talking about. I mean, there's probably subject to a bit of negotiation because there might be a bit of pushback by the administrator saying, well, actually, you've already getting it at a discounted value. So using your example, we might say, actually, tell you what, I'll share that pain with you and only reduce the price by £100,000. So down to 800. So that, as you say, that's a legitimate reason for asking for a reduction in the price because it's going to cost you to restore it, achieve full value for it.
Excellent. Right. I think that's about the end of the video. Have you got any words of wisdom for my viewers?
The first point, I think, is if you are buying any asset, whether it's a business or whatever the case may be, make sure you go out and see the business. Look at what you're buying. Talk to the employees, talk to the management team, understand why that business has got into the situation it has. Why is that business on the cusp of insolvency? So you can understand what the pitfalls are, so it allows you to price your bid accordingly in order to make sure when you do acquire it, you can make a successful return on it.